Okay, we're on the record.
Thank you. Good afternoon. My name is Justice D'Angelo. I am the single justice for this afternoon's case. The docket number is 23-J449, Deutsche Bank versus Jeannette Detiberus. I hope I pronounced that right, ma'am.
Detiberus.
Okay. Ma'am, since this is your appeal, I'll hear from you, and then I will hear for counsel for Deutsche Bank. So go right ahead.
Good afternoon, Your Honor. I'm filing this because they set an appeal bond in use and occupancy, and I feel that I haven't had any kind of evidentiary hearing, anything for all the wrongdoings with the bank. And I don't believe, because I am indigent and my son's indigent, I'm not sure if I'm saying that correctly, that I should have to pay, for justice to seek what's right in my case. And we've never had an evidentiary hearing at all. So I believe it should go before another judge to actually look at the evidence, to see all my evidence that I have, which I feel that I could have a winnable case, but I've never been able to show all of that. It just keeps getting brushed aside. And so my thing is, I would either like to have my bond and use and occupancy stayed until the pending of any appeal, or to have it waived. Whatever the court, All
right. Can you tell me what issues you think you have a right to appeal on?
Yes. Obviously, you probably don't know too much about the case. My mom passed away in 2018. I've lived in this house for over 20 years. I'm her sole heir. They foreclosed on a deceased person without acknowledging it. They didn't give me my rights to be for notification. There's title issues. There's also issues with her signature on the mortgage. They actually sent me letters stating that I do have an interest in the house prior to her death, because they didn't acknowledge her death at first. Then they defaulted her for not showing up in court because she was deceased, and that's how they won that, saying that they didn't know. But then they sent me a letter stating that they did know and that I am the sole heir. And then they said, well, that doesn't matter. The previous judge, when it agrees, he believes me that they didn't send me the loan modification papers as they were supposed to in the very beginning, but then says that that doesn't matter. So I just believe that if I show all these things and all my proofs, and it's right in front of them, and they could actually look at it, another judge or a jury or whoever would look at it would see that I do have a winnable case.
All right. My understanding in looking at the docket from the housing court was that there was a hearing on May 31st, I believe, 2023.
Yes.
At that hearing, when you say that you were not able to present any evidence, that was what's called a summary judgment hearing. Prior to that hearing, why didn't you submit your evidence to the court before that hearing?
I did submit my evidence to that. They were just saying that it didn't matter.
Okay, so the judge in the lower court did have the evidence that you say is important. It's just that the judge didn't feel it was meritorious.
Right. And then I do have a couple other issues. My son, who lives with me, he's 24, he's disabled. They said that, basically it doesn't matter. They won't let him have his day in court or anything. I actually put in an appeal to the appeals court, and they told me that they wanted to wait to see what the outcome from the summary judgment was first before they would rule on that, which that seems very fair to do. I guess I just don't understand. Oh, excuse me. I have to back up a little bit too. On the bond order, it also stated that that the plaintiffs would continue to pay the water bill along with the taxes. Now, they did take on the taxes, but they've never taken on the water bill. That's still in my name. I'm still obligated to, pay that myself. So I wasn't sure if that was, put in with the determination of what my use and occupancy was as well.
Okay, and I also know that I believe it was a something that you filed on your own, that you believe that the entire matter should be stayed because of another case that's in front of a single justice or
Yeah.
referred to a panel. Okay.
Yeah.
All right. All right. I'll hear from Attorney Polanski on Deutsche
Thank you.
Bank's behalf. Thank you.
Thank you, Your Honor. Good afternoon. Attorney Kevin Polanski on behalf of Deutsche Bank. These issues were discussed and addressed by Judge Winnick in the lower court. In fact, summary judgment was pushed off several times to allow Ms. Detiberus to present her evidence. That was continued several times over my objection. And her evidence was submitted and the court disagreed with it for multiple reasons. I mean, I'll quickly address just some of the things that she just mentioned, which is she says she didn't receive notices in one hand, and then she goes and says, well, I did receive notice. I should have all these things. None of the evidence actually amounts to any actual claims or defenses. And Judge Winnick reviewed it to his credit at nauseum and went through it methodically. In fact, in his order for the bond, he doesn't just say they lack merit. I think he says they egregiously lack merit. And so this is nothing more than a delay in trying to prevent us from obtaining possession. Now, Ms. Detiberus is entitled to appeal. That's fine. But under 239, Section 5 and 6, which has to be read in conjunction with each other, under the King case, she's required to post a bond if two conditions aren't met, and use in occupancy, even if it's waived. Judge Winnick found that she had to post a $100 bond. He did not waive it because her claims lacked merit. Now, he did find that she's indigent, but she still has to prove that her claims have some sort of merit. And he didn't agree with us in that the bond was supposed to be from the date of the foreclosure sale to the present, and we didn't appeal that. So the bond as it currently stands is $100. He also, to her credit, even though she provided no evidence of fair market value, he did find that the fair market value is $1,700. But because she pays the utilities as a tenant in sufferance and the water bills, he also made note, and he was very specific in his findings, that she would continue to pay those, but he wasn't going to make her pay both. It was a $1,700 and a reduction for utilities and water. So he methodically went through and looked at everything. I mean, I give him a lot of credit because a lot of judges in these decisions don't do that. And he has addressed all of these issues. I think the order should be affirmed. I mean, these orders are required for two reasons under the legislative intent. One, to deter frivolous lawsuits and appeals, and two, provide some level of protection for the plaintiff while this appeal is pending. This does just that. It's not a significant award. It's enough to deter a frivolous lawsuit, and it's enough to provide some protection to my client.
You understand, counsel, that another single justice a few months ago has reported some questions to a full panel of the appeals court. And after that single justice did that, a subsequent single justice basically did the same thing. Why shouldn't I do that in this case? Because
prior to that, these decisions have been upheld, and there's no inclination that those single justices certifications to SJC is going to change anything. I mean, King is clear. King says you've got to read sections 5 and 6 together. When you read 5 and 6 under 239(5)(e), it says if you waive the bond, even if you waive the bond, you still have to condition use and occupancy on a go-forward basis, and that's what Judge Winnick has done here. And so I think even under King, which is established judicial precedent, that's what it requires of the courts. And Judge Winnick followed that. He cited to it numerous times in his decision.
Okay. All right. Thank you both very much. I will issue. No, ma'am. There's no rebuttal in the appeals court.
Thank you.
Okay.
I just wanted a rebuttal, though. It was something I left out in my saying. I'm sorry.
All right, go ahead. I'll let you say something you forgot to say.
I just wanted to say that I'm not a traditional tenant. I've never had a lease agreement or anything with the plaintiffs at all. So I don't feel that I fall under the 239 which I should have said in the beginning, and I'm sorry.
That's okay. All right.
Thank-
Thank you both very much. I will issue